There are 5 stages to a criminal case in Louisiana. You have the first appearance, the arraignment, pretrial motions, pretrial conference, and a trial. The first appearance is when you go in front of a judge, you're told what your charges are. Generally at this time, you'll also appoint you counsel if you need it and set bail. That first appearance where there's that probable cause determination is in 48 hours of your arrest. The counsel determination has to be done within 72 hours. Again, those are normally consolidated and bail is also set at the same time. That's the first stage. Second stage is the arraignment. This occurs when someone is formally charged. They're brought into court. They may be charged with the same thing they were arrested for. They may be charged with more things. They may be charged with less things. It's entirely up to the district attorney what someone is charged with. But they could go in front of a judge. They can just say guilty, not guilty, no contest, or a lawyer can enter a insanity plea on their behalf. And then depending on what plea is entered will determine where the case goes as far as sentencing, getting set for trial, or having a mental evaluation of the person. Assuming a not guilty plea was entered, the third stage would be motions. There are 2 types of motions. There's paper motions and there's substantive motions. The paper motions are where you ask for things in discovery. You want to get the police reports. You want to see if there's any forensic analysis reports that were done, any expert reports that were done. You also want to get crime scene photos, autopsy photos, recorded statements of witnesses. Those are all paper discovery processes. You can also do some substantive motions, preliminary hearing, where a detective takes the stand and summarizes the case against you. Suppression hearings, where you say certain pieces of evidence were gathered in violation of my constitutional rights and should be excluded from trial. Or motions in limine, where you seek to shape how the trial will take place, saying that, hey, look, some evidence may have been constitutionally obtained, but there's some other evidentiary reason why it should not be admitted against me at trial. Once all those are done, you then go to a pretrial conference where you'll discuss how the trial is going to take place, how the judge likes picking the jury, things of that nature, any time limitations, any special issues. This is also a chance to discuss the case, any possible resolutions. Different jurisdictions do this differently, so I'm just putting a lot of concepts into one category as the pretrial conference. The last is the trial. This is where a jury is impaneled. They hear the evidence of the case. The district attorney presents it. The defense attorney cross-examines it. If the defense attorney wants to put on evidence, they can. And then they make closing arguments and the jury decides it. This is where all your lawyer shows are. They just focus on the arrest and the trial. That is the trial. Obviously, after the trial, there could be some other stages. I was just assuming for purposes of this video, the defendant wins, but upon conviction, there's post-trial pleadings, sentencings, and appeals, and we'll do that in another video.